you, and
Senator
my apologies.
Thank you, Mr. Chairman. I want to follow up with Judge Netburn regarding the JJS case. I've been reading through your report and recommendation, and I just want to review the fact that this was an individual, JJS, who had raped a 9-year-old boy, raped a 17-year-old girl, was put in prison, went to prison for a long time. After that person was paroled, JJS, the way you put it on page 44 of the report and recommendation was that that JJS sent 2 sexually explicit images of minors in 2015 while out on parole. I should point out this is kind of a euphemistic reference. These were not just sexually explicit images. These were sexually explicit images of adults violently molesting children, sexually assaulting, abusing children violently. Every time this person has had an opportunity to offend, this person has offended. And yet you recommended this person against the recommendation of the U.S. Bureau of Prisons to go to a women's facility. Now, your reasoning here is stunning to me. Going back again to page 44 of your report and recommendation, you say, quote, "There are no signs that petitioner is at risk of reoffending." I'm struggling to understand how you could possibly conclude that, because the minute this person was released, this person engaged in other offenses. Yes, not a contact offense while out on parole, but there are still issues going on. It says nothing. You don't adequately grapple with the obvious fact that this is a 6'2" biological male. Yes, transition aside, the transition didn't begin until age 51 or 52. By then, JJS had acquired all of the physical, biological size and strength advantages of being male. Those don't go away because there is a transition. On what planet does it make sense? On what planet does that person with that sexual offense history, with being biologically male and also 6'2", not pose a threat to the safety of female inmates? I don't understand how you could conclude that this person shows no risk of being an offender. Now, you argue at one point that this person has shown no pattern or history of offending while in prison. Yeah, because JJS was in prison with a bunch of other men where the size and strength differentials aren't quite the same. Can you help me understand this?
Thank you, Senator. First, the crimes for which the petitioner was convicted are horrific. I've been a sitting United States magistrate judge for 12 years. Sexual offenses against children are among the worst crimes that we see. This person was convicted by guilty plea 30 years ago of 2 awful crimes and was sentenced to a very significant prison sentence by the state court judge. About 8 years ago, the petitioner committed another awful crime, the crime of distribution of child pornography. That is an abhorrent crime, and there are real victims. And the petitioner was sentenced by the Indiana federal court.
I understand this. This is all undisputed. What I want to know is, why is it okay? Why is it safe? Why is it fair to female inmates to send this person to a female prison? This is a guy who raped a 17-year-old girl and a 9-year-old boy. Why is that safe? 6'2" biological male.
Senator Lee, as I do in every case before me, I look at the record evidence. I consider the facts before me. In this case, the facts that I considered included that every single warden who supervised this petitioner recommended that the petitioner be transferred to a women's facility because of her serious medical needs, because she had engaged in no violence, no infractions, and in fact had been the victim of sexual assault.
While in a male prison, and this was against the decision of the U.S. Bureau of Prisons. Judge Valenzuela-Dixon, do photo ID laws violate the U.S. Constitution? Does it violate the U.S. Constitution to require someone to show identification when casting a vote? Does it violate the U.S. Constitution? Is it unconstitutional?
Please turn on your microphone. Thank you.
I
Thank
asked
you,
because
Senator.
you submitted a brief in a case called Crawford versus Marion
Yes.
County Election Board. And in your brief, you argued, quote, the striking similarities between voter identification laws and poll taxes this court rejected less than a half century ago demonstrate that identification requirements are unconstitutional regardless of the level of scrutiny the court applies. The court, of course, disagreed with your assessment.
It did.
So what's your answer to my question?
The Crawford case made it clear that voter identification laws are constitutional, and I would follow that precedent.
Do you agree with that precedent?
That photo ID laws are constitutional?
Yes.
I do, Senator.
And yet you argued to the contrary in that case. Did the court convince you?
Well, the court stated what the law is, so I would follow the precedent of the Supreme Court.
Thank you.